welcome everyone today. We are really excited about this program, an overview of nonprofit law for legal professionals. And we're very lucky to have a panel of just really wonderful attorneys that I have, really enjoyed working with on this project. We have Claudia Williams-Hyman with West Tennessee Legal Services with us. And also we have Rita Gibson Rayford, Harolda Bryson, Seth Ogden, and Jerry Taylor. And the five of them are going to, just talk about, as the title suggests, nonprofit law. And I just want to give a quick housekeeping note. If you do want to receive CLE for this program, if you could please email me, Brooke Leeton, at the conclusion of the program. I am happy to send you that certification link, and you can certify, and we will go through the motions of getting you CLE credit for this program. But I don't want to waste any more time. I'm going to hand things over to, I believe, Claudia or Rita with
I think it's Claudia.
Claudia. Oh, okay. All right. Thanks everyone for being here. And to the five of you, thank you so much for being here. And away you all go.
Wonderful. Thank you so much, Brooke. As Brooke mentioned, we are so happy to have you all here with us. Good morning and good afternoon, depending on where you're joining us from. I want to welcome you all to our panel discussion today on nonprofit organizations and the legal issues that they face. We are thrilled to have you with us for this continuing legal education session, which is the first of three and maybe more in a series. My name is Claudia Williams-Hyman. I am a civil and human rights attorney by trade, and in my current role, as Brooke mentioned, I am the pro bono staff attorney with West Tennessee Legal Services. We have such a fantastic and knowledgeable panel today, and so I also want to give everyone an opportunity to introduce themselves as well. And just to also add, I will be moderating our discussion. And so I'll kick it off to you all to introduce yourselves, and we can start with Rita.
Hello, everyone. I am Rita Gibson Rayford. I have my own public interest law firm, but for more than a decade, I was a legal services employee. I was a chief development officer at Memphis Area Legal Services. I also served as a managing attorney. I've got a lot of decades of more than I would like to say the exact number, but a lot of decades of experience in nonprofit and public administration. I've taught in higher ed, nonprofit law, public interest law, and a number of other things, including administrative law. So I'm just glad to be a part of this really great panel, and I'm sure that we're going to learn a lot today and share a lot today. So I'm glad to be here.
Excellent. Seth?
Sure. I'm Seth Ogden. I'm a little bit of an odd one out, I think, here because I'm actually an IP lawyer, patents, trademarks, everything branding, trade secrets. But the reason I'm here is I do a lot of work with nonprofits. I serve on the board of Operation Stand Down, which is a veterans nonprofit that assists veterans in crisis, also helps with job placement. If you'd like to know more about it, I would love for you to get in touch with me. I also, on the side, do pro bono work helping veterans get their disability benefits. Also, if you need help with that or anything, call me on that. And then I've just joined the legislative committee of the Sexual Assault Center. So I have a fair amount of experience in kind of seeing how governance works. I've been the governance chair on nonprofit boards, and I'll probably focus on talking about some branding issues to think about. But I'm open to any questions and anything anybody has just about an experience with more of a, I'd say a mid-sized nonprofit of 50 to 70 employees, because that's kind of where my bread and butter has been. Thank you.
Awesome. I'll kick it over to you, Harolda.
Hello, everyone. My name is Harolda Bryson. I currently, by trade, am a municipal attorney. I'm an assistant city attorney for the city of Chattanooga. I've been doing that for about 7 years now. Got involved with this panel because similar to Seth, I have quite a bit of experience with serving nonprofit organizations on various boards. And I originally got into nonprofit board service through my passion for the arts. Currently, all of the boards that I serve on are for arts nonprofit organizations. And again, it was really to connect with the arts community here in Chattanooga, which is where I'm located. But once I kind of got into it, I really realized that I have a passion for nonprofit board service. So I'm excited to be here.
Great. And Jerry.
All right. Well, good morning or afternoon, as the case may be. I'm Jerry Taylor. Like Seth, I'm in private practice. I'm a partner with the Thompson Burton firm in Nashville and Franklin. My area of practice is actually in healthcare law, mostly on the regulatory compliance side for healthcare providers. I got started on the nonprofit board area really when I was just back in the Stone Age, I guess, when I was a baby lawyer coming out of law school. And don't recall really how I first got on my first one, but I've been on a number of boards since then. Really enjoyed it. I think it's one of the one of the best forms of community service that I can do. And so I've really enjoyed that. I'm glad to share with you whatever little bit of knowledge I may have gained over the years. And I just appreciate being here and the opportunity to be on this esteemed panel, and hope we all learned something today.
Great. And I want to reiterate, as Brooke has mentioned in the chat, if anyone has questions, we want this to be as conversational as possible. If you have questions, if we raise something during the discussion that you would like to know more about, please feel free to drop those questions in the chat. We would love to hear from you. And so I think we should begin at the beginning. Today, we'll start with discussing the nonprofit formation process. We'll start by talking about some foundational issues, starting a nonprofit, structuring a nonprofit, and this process raises a lot of important legal questions. So we'll start with Rita. Rita, will you talk to us about the key legal steps that someone should take to form a nonprofit in Tennessee, and talk about the way that you guide clients through that process?
So when clients come, and not only clients, but just people I know are in the community, and they talk about they want to start a nonprofit, the first thing I start with is that you have to understand it's a business. If you think about the nonprofit being a sector, you have the private sector of, corporations and businesses whose primary focus is to make money, and then you have the nonprofit sector and you have the public sector. So when someone wants to form a nonprofit, I always ask, well, what is it? Why? What's the focus? What's the vision, and what's the mission? Oftentimes I find that a lot of people want to start a nonprofit, but they would be better suited forming a for-profit business, because they always think that they're going to own the nonprofit organization. I want to found a nonprofit, and they might have, a charitable mission or focus. However, they want control over that nonprofit. And that's one of the fundamental things I discuss with not only clients, but people that, just come to me for, some guidance about starting a nonprofit, is thinking about what your business structure is going to be. And so if you have a business structure in mind that's going to be suitable to be classified as a nonprofit organization, I go into there are two different really considerations: your federal requirements and your state requirements. So the business formation part of that is going to be under state law. In Tennessee, the Secretary of State is going to govern that. And even though the nonprofit's focus is not to make money, I always advise them to start thinking about not only business structure, but how they're going to operate the business and having a business plan. That's going to be a little different from a for-profit business. However, they do need those fundamental things in place, that plan in place, when they start to plan out what they're going to do. Some people will, start off by just going to the Secretary of State's website and paying $100 and filing, a charter or articles of incorporation, and they've got a name and they've got, their idea that they're going to form this nonprofit, and they go ahead and do that. I always say start with the plan first before you actually take action. With a nonprofit, you're going to be formed under state law, whatever state you're going to be in. And in this case, it would be Tennessee. Secretary of State has a wonderful guide, and that's one of the resources that we're going to make available to everybody that's attending this today, about the steps of filing, not only filing your paperwork with the Secretary of State, but also everything that you're going to need. So, of course, you need a unique name. In Tennessee, you'll need at least 3 board members. You'll need at least one person that's going to act as the incorporator. So that's the person that's going to file the paperwork. You need to think about what the bylaws are going to be, what your governance structure is going to be. There are requirements from the state about filing afterwards, your annual report. You need to think about that. And also operationally, how are you going to fund that nonprofit? Is there going to be, some initial investment on your part? Or do you have some supporters initially that are going to help with the operational costs of getting, I don't know if you're going to have a building at first or you're going to rent office space. You need some type of structure for that. In addition, you need to think about not only the business structure, but some of the background of it, the administrative aspects of it. You'll need a registered agent. That's going to be an entity that is going to accept legal process for the organization, maybe tax documents, also registering with your county. Usually, if you're in Shelby County, you just go to the county office and give your paperwork. I think years ago, it used to be less than $10 just to file your paperwork with the county. But those are things that you need to think about. On the federal side of things, that's where you're going to get your EIN, and you're also going to basically fill out your paperwork regarding your classification as a nonprofit. Most people think I'm going to start the nonprofit and it's going to be a public charity, but there are specific criteria that you have to meet in order to be the 501c3. Everybody thinks I'm going to be 501c3. There are 29 designations in the Internal Revenue Code for nonprofit, most nonprofit organizations. There are some specific ones that are outside of the 501c designation, but usually there are 29 that we refer to, and 501c3 is going to be that designation that most people want in order that they have tax exemption, number one, and number two, that donations to the organization are going to be tax exempt for the contributors or the donors. And so those are some of the things that I walk people through when they ask for guidance, whether they're a client or whether they're somebody that's just thinking about it.
Thank you, Rita. And I know you talked a little bit about the difference between a private and public charity. Another question I think that comes up a lot is what is the difference between a 501c3 versus a 501c4, which are entities that are a bit more commonly known. Can you talk a little bit about those differences and when you advise individuals to lean more toward one structure versus the other?
Well, the designation that you have under the Internal Revenue Code is going to be determined by the criteria that the IRS sets. For 501c3, a public charity needs to have, number one, broad public support. And in addition to that, they have to fall within certain categories. So educational purpose, a religious purpose, a charitable purpose, a scientific purpose. When you're talking about a 501c4, you're not going to necessarily have the preferential treatment on donations of tax exemption for donations. And those organizations under that specific code or section of the code are going to be more aligned with advocacy organizations or social welfare. So think about your homeowners associations or an entity like the National Rifle Association. They are advocating for the benefit of their members as opposed to the public in a specific area. So if you have a religious organization, they're not advocating specifically for members of the church. They may be a public charity where they provide programs in the community, that they get broad public support through donations, not only from their members, but also the general public or other funding sources, whether that's federal government, state government, whatever. But a 501c4 is going to be basically organized for the benefit of their members instead of just a broad public charity. And so that's usually the distinction. And every part of the code under 501c, there's those subsections are going to have specific criteria that an organization is going to have to meet in order to be classified under that specific designation. But usually when someone comes to me, they want to be a 501c3 because that's the most tax advantaged designation that you can have under the Internal Revenue Code.
Rita, we have another question that I think would be good to take up right now. John Rexford from Chattanooga, he says that his interest is in nonprofit laws that pertains to churches. I know you mentioned church as an example of the 501c4, I think. Are there any other Is there any other difference in forming a nonprofit for a church than for other
Well,
types of
no,
organizations?
many churches actually fall under 501c3. So that's a great point to make. That is usually your 501c3 will encompass a religious organization, a church. And usually the churches are not going to fall under 501c4, which are really advocacy and member focused organizations. So yes, a lot of religious organizations and churches fall under 501c3. And they enjoy the tax exempt status. And I know, Jerry, you're going to talk a little bit about unrelated business income tax, but usually for regular donations, those are going to be exempt. They're going to be tax exempt.
Thank you for that question. And if anyone else wants to jump in on this question as well, it is so important, the foundation of the nonprofit organization. And I want to direct this question to Seth, but anyone feel free to join in as well. What are some of the common pitfalls that you've seen during the formation process that can lead to problems later down the line?
That is a super important question because governance is much more important than I think people realize. It sounds like a fancy word, and so the question is, what does that really mean? And it means, how are things going to run? You need to have rules. And so a lot of times there's a lot of excitement around starting a nonprofit, and you kind of put off those aspects as just paperwork. And it's like a paperwork exercise. Let's get all this stuff done so we can get rolling and get on our mission. But there's really kind of, I don't know, three main things and a fourth one that is important to me, but it can come back to be a problem. So the first one is your mission statement. It's more than you think. It's important for your public view aspects, but also you don't want it to be too broad or inconsistent with the IRS requirements for being a 501c3 or a 501c4. And you don't want to somehow have a mission statement that causes a delay in your tax exempt approval or could limit what activities you're going to do later. So it's really important to think about that. You can obviously pivot and alter that later on, but there should be real thought put into the mission statement. A big one that I've seen actual problems result from is weak bylaws. A lot of times it's, easy to adopt some generic bylaws, especially these days. You can pull them off the internet. I'm sure you could have AI generate them for you. But if you're going to, and that's fine to use that as a starting point, but you want to go through and think about what is it that your organization is doing and how are you going to set those bylaws up and tailor them for the actual operations. And they're going to have to change over time. So this is a recursive exercise. We go back and revisit our bylaws, I think probably every year. I just got done doing some red lines. And because what you want to do is you don't want to have confusion around board terms, the quorum requirements, the officer responsibilities. You want to be sure all these are satisfied every time you have a meeting and that you're doing all the things each year that you have to do. And having really specific bylaws, it's just helpful. I mean, and for example, when I talk about the terms, you know, you can always set it up to be able to vote to have an extended term for someone, but it makes it easy. I hate to say it, but sometimes you may not want someone on the board anymore. And if you've got everything laid out well in the bylaws, then you just say, according to the bylaws, your term is up. And so unfortunately, you're going to have to roll off at the end of this year. And it makes that clean and easy. And you can think of it again in a business having really set out employee handbook rules about when, say, if an employee, it's kind of negative here, but if an employee does something, are you going to discipline them? Are they going to get fired? Are you going to have criminal charges brought against them? Like, if you have that laid out, then there's no question, there's no issue about discrimination and that sort of thing. So just having these very specifics in the bylaws and then coming back each year and saying, we dealt with this issue this year and we didn't have anything in the bylaws that told us what to do. For the benefit of the next group on the board, we should write into the bylaws kind of how this will work. So I think that is like a big focus at the beginning. This ties on to that. The third point is a failure to document roles and responsibilities early. So early on, you want to have the board and the volunteers, you want clear expectations about how decisions are going to be made and how conflicts are going to be resolved. And it's important to decide, what type of voting has to happen. There's things, as an organization grows, you may give the CEO permission to approve expenses up to a certain amount without board approval. And you may find as the group grows or as things get more expensive, $5,000 isn't enough. They should be able to approve a $10,000 expense. So they're not coming to the board every time they need to do X. And again, this is recursive because it'll change depending on what kind of activities you're participating in. So these things can be really important. You have to have people with roles in terms of documentation and all the documentation that will be required for whatever grants you might use or those various things. So setting out that stuff early and having a plan is really important. And then the fourth point that I said is kind of more personal to me, and it depends on what you're doing, but you need to plan a little bit for IP ownership because you're going to probably design a logo. You're going to have a brand name. You're going to have website content. You're going to have program materials. Are you going to have volunteers that do that? A lot of times companies like a marketing company may donate their time. Are they going to assign all the rights to the designs they give you? How's that all going to work? And just to make sure you don't have legal problems down the road, it's a good idea to be vetting the written agreements and those sorts of things. So, I mean, honestly, I've found that it's really helpful if you can get a couple different types of attorneys to either volunteer their time or to serve on the board so that they can review these things because you don't want to go and pay an attorney for that kind of knowledge. And it's the kind of thing that we have, like I can immediately give you the answer. I don't have to go do a lot of research to know what you need to do. And I see a comment in here. It's a good to have a work for hire IP provision. That's exactly right. There's these magic words that create this work for hire relationship with what's called a present assignment clause. And I'm going to talk a little more about IP in a little while, so I'll wait for that. But that's exactly right. Understanding what provisions should be in your agreements. The biggest problem I see is contracts get signed with nonprofits, and then bad things result a year or two down the road because the implications of the contract weren't fully understood. And so those are the things that you can start to deal with up front by delegating responsibilities for contract review and for maintaining those and keeping up with those, auto renewals, all that sort of stuff. So I think that's the overarching message is from what I just said is it's not a paperwork exercise. You need to give it diligent thought and tailor it to what your plan is for your nonprofit.
Thank you, Seth. And you also mentioned recommending attorneys serving on the board as well. And I think that relates to two of the questions that we had come in. One of them is from George, who asks, regarding compliance with governance requirements, would the panel please address potential ethical pitfalls for attorneys who serve on nonprofit boards but are not retained as general or outside counsel? And I'm going to raise the other question as well, which I also think relates to the situation where we have attorneys serving on boards. Do you prefer legal counsel on a board, be voting or non-voting members? Sarah offers that she leans toward non-voting, but she's served on boards as both. So I expect we have a lot of folks here who are interested in that sort of dual role of serving as an attorney on a board. And so can you all speak to that and specifically the ethical implications of serving in that capacity?
Well, I'll comment on that a little bit. In a few minutes, I'm going to talk about the fiduciary duties that a board member has to the organization. Um, and those are important. But if you get into the role as an attorney on the board, and you're now being asked these legal questions, which you always will be asked legal questions if you're an attorney on the board. Um, as you know, the whether there's an attorney-client relationship is not what I, the attorney, think it is. It's what you, the client, think it is. And so, one thing I'd be a little bit careful about is when you are when you're answering legal questions, be mindful of the fact that you may be establishing an attorney-client relationship there, and that brings in a whole nother set of fiduciary duties and ethical duties or ethical obligations. So it's a little bit of a sticky problem, but it's always going to happen. They're always going to turn to the attorney, for they have legal or even semi-legal questions. So just I guess keep that in mind.
To piggyback off of what you're saying, Jerry, I think that it's best to have outside counsel. As an attorney, of course, you say that we're always going to be asked questions, but you have to think about, of course, what's the scope of your responsibilities. Where you're on the board of directors, you are a fiduciary, like you said. So you have certain obligations to the nonprofit organization. In addition, you don't want to act outside of the scope of your responsibilities and open up legal liability. I can see instances where an attorney is on the board and they're asked to look over a contract. I think you need to make it clear in that instance, this is not legal advice. I'm just reading the contract. I'm telling you, specifically what are the things, or I'm telling the board what are the things that we need to consider as the board of directors. But you really need to be mindful of what the scope of your duties and responsibilities are as a board member versus an attorney, and making sure that you don't assume the role, like you said, of delving into the area where you are now giving legal advice, giving legal representation to an entity that you're, number one, a part of. There may be an inherent conflict of interest. So there are some things that I think if someone wants you to look over a contract, or they want to you to look over a personnel manual, I think that's fine, but there needs to be a clear delineation between what your responsibilities and your roles as a board member are, your obligations are, and then what are your roles as an attorney. And you don't want to create an attorney-client relationship that's also going to create a conflict of interest that might not be waivable. So a lot of nonprofit boards will have outside counsel. They might not, they're not coming to every board meeting, but if there are legal issues, whether it's in the employment arena or it's a contractual issue, whatever it is, you can call on that outside counsel to basically give the nonprofit board the guidance and the advice that they need in order to make a decision as a board, instead of one person or two people acting as the de facto attorney because they're serving on the board.
I'll piggyback off that and just confirm that in my experience, I don't know about the voting versus non-voting. I have been a voting member. I don't think that's a problem, but I may not know something that someone else knows. But when it comes to now we need legal advice, now we need representation, that it's absolutely correct. We go and get outside counsel, especially, on an employment issue. We may have employment lawyers on the board, but they are going to say it's time for us to hire counsel. Now, I will say you need to be careful about it, but it is okay if you want to take on representation. For example, say I want to help get a trademark. That's fine, but you need a very specific engagement letter that is limited to that matter that you're going to handle, so that you're not accidentally creating an attorney-client relationship for other issues that relate to your board service. So it is very important to be mindful of that for your own ethical aspects.
Thank you all so much for weighing in on that. I think the key word there is clarity. Clarity about your role, clarity about the scope of your role, and anticipating that as a nonprofit organization, it is likely that you are going to need legal assistance at some point. It is highly unlikely that you will never need counsel to weigh in on some of these questions. So great advice. And I think kind of shifting out of the nonprofit formation process, the work does not stop there. So I want to talk a bit about compliance and IRS regulations as well. Once a nonprofit is formed, ongoing compliance with the IRS rules and regulations is very important. I'm going to send this first question to Rita. Can you talk about some of the key annual IRS requirements that nonprofit organizations tend to overlook?
I think the number one is just timeliness of filing. So if you're required to file, it's not really called, we call it colloquially a tax return, but basically if you're tax exempt and you're not paying taxes, it's not a tax return. So just filing your your informational returns to the Internal Revenue Service timely, and making sure that you're doing that on your schedule every year. If you go and look at, 990s, you can usually see, the delinquency that people have. So this is all public information. Anybody can look up a nonprofit organization that's tax exempt under their Internal Revenue Code and see the history of your filings. That's one thing that when I serve in the capacity of being on review boards for granting organizations, whether it's like a public entity, a city or whatever, that's one thing that we look at. Are you filing your compliance documents on time? Are you delinquent a couple of years? All of that is readily available for anybody to look on the Internal Revenue Service site or nonprofits that are kind of like aggregator sites and see whether you're compliant. And that really plays a role, not only just from a compliance standpoint of you doing what you're supposed to do to be in good standing with the Internal Revenue Service, but it can have huge implications for a nonprofit that is seeking funding, whether that's from private foundations or local entities or federal government agencies. It's incredibly important. So that's like the number one thing I think is timeliness. And the second would be accuracy, filling the forms out completely and honestly, and not trying to or attempting to kind of fudge things. What were your gross revenues for last year? How many grant funds do you have? What were your actual contributions from individuals and other entities? What are you paying your staff? Accuracy and honesty would be the second one.
Rita, we have another question. I think it's really probably more appropriate for the last session or topic, but I think it'd be good to go ahead and talk about here. This is from Amy Brown, and she says, is lobbying or advocating by a 501c3 without 501c4 status a common or a dangerous issue? Any suggestions for where to begin looking for guidance on limits to these activities or the interpretation of advocacy or lobbying? And I think that's pretty much it. It's a little bit more of the question there, but I think that's the gist of it. I hope I got the gist of it, Amy.
Yes. So 501c3s have really strict prohibitions on lobbying, as opposed to 501c4s. And that's because they're supposed to have broad public support, and contributions are usually going to be tax exempt to the donor and to the organization. And so the place that you need to really go is to the Internal Revenue Service. The Internal Revenue Service site has a plethora of publications and also training modules and videos regarding issues that can get you into trouble. And lobbying is one of the top ones that the Internal Revenue Service looks at for 501c3s. And so they have a lot of publications. I would say go to publication 557, and that's one of the ones that we're going to have as a resource. Just to look at the overview of restrictions on lobbying. So a lot of nonprofits will not lobby directly, but they may have a lobbying organization that they pay for limited lobbying. So they might be a part of a larger entity, like an outside organization or membership group that lobbies on behalf of similarly situated nonprofit organizations, and they're not doing it individually. But that is a big area that you have to be cognizant of. And it's something that board members, when you're thinking about board governance and what's the roles and responsibilities and duties of the board, that's one thing. Make that one real big thing, making sure that you're not violating political activity limitations and restrictions imposed by the Internal Revenue Service, and also lobbying restrictions.
Thank you.
And I'll jump on and just say, look at the materials, but just the general kind of overview is you can engage in insubstantial lobbying as a 501c3, and there are some opinions out there that actually kind of put percentages around that. But what I have seen is typically that can get messy. It requires a lot of tracking. And so having another arm that is a separate organization, if you're really going to do a lot of lobbying that is authorized to do that and is not the nonprofit, that is the way that many people handle that. I will say if you're a 501c4, you should look at the materials because you do have a little more options in terms of that and what you can do in terms of lobbying. So, we're not going to give legal advice here, but you're allowed a little bit, but think about it more about instead of lobbying, you want to do educational advocacy, which is like providing nonpartisan research, hosting a public forum. That's kind of a better way to do it. And then I know that some organizations utilize volunteers for like a day on the Hill. I'm not sure how all that falls in there, but it's being done. So I would assume that like it's permissible. That way, I don't think you're really spending any of your budget, but you should look in the materials and see if that might be an option for you. I've participated in that before, and that can be pretty effective. Like once you've gotten, someone who's going to introduce a bill that you're in favor of, volunteers go who would be in that person's district, for example, or in one of their people's districts, and they go and talk about that when it's coming up for the vote. So these are things to look at, but you want to make sure they all fall within those guidelines.
We have another question sort of following up on that. Are there any nuances around lobbying in the state of Tennessee at a state level that they should be aware of? I don't know.
When you're thinking about lobbying, usually people are usually focused almost exclusively on the federal implications of it. But yes, you do need to be cognizant of that. Your existence as a nonprofit, let's just say, some of the three most common business formations that you're going to have under any state's jurisdiction for your business entity is going to be a trust, an association, or a nonprofit corporation. If you're a nonprofit corporation, that designation as a nonprofit organization comes from the state. In our case, it would be the state of Tennessee. And so the Attorney General's office is usually going to be the compliance arm that is going to make sure that you're basically in line with lobbying and solicitation restrictions. And so the Attorney General's office has also guidance for nonprofit organizations. Of course, there's case law and opinions about that, but the Attorney General would be the entity that you can go to for more information regarding state restrictions and the activity that office for charitable organizations, what they want to see and they don't want to see for charitable solicitation activities and lobbying. But again, as Seth indicated, a lot of nonprofits, 501c3s, they have separate entities like we talked about that go and lobby for them. And usually on, let's just say you're applying for a grant, a federal grant, usually you in those applications, you will be asked, the nonprofit organization will be asked to list if you have a lobbying agent. And so lobbying is not prohibited. There's just restrictions on it, especially for 501c3s. And I see another one about what does the panel recommend as far as malpractice insurance and or D&O insurance for retired attorneys. My recommendation is that every board member, whether you're an attorney or not, should have D&O insurance, directors and officers insurance.
Thank you so much for that, Rita, and thank you for that question as well. On the topic of compliance, I know one of the big areas of concern is related to unrelated business income. Jerry, can you talk to us about what unrelated business income is and why it can be a trap in the nonprofit realm?
Yeah, I'd be glad to. I guess I should make a disclaimer on the front end. Tax law is not really in my wheelhouse. Well, it's not at all in my wheelhouse. But I'll be glad to share some thoughts with you about unrelated business income. It's fairly basic stuff. I'm going to do a screen share here. If I mess it up, I apologize, but I think I can do it. Can everybody see that? Looking good. All right. So when we talk about unrelated business income, you want to contrast that, or if it's unrelated business income, what's related business income? And related business income is just the income from activities that directly further the organization's exempt purpose. The activity is integral to its mission, and that type of income is typically not subject to tax. That's going to be, considered related business income. There's an example: a museum charging admission fees or selling educational materials about its exhibits. These activities support the mission of public education, so the income is considered related and tax exempt. On the other hand, if I can get forward here, when you talk about unrelated business income, so this is sort of, I guess, in a way, is the opposite of related business income. It's income that's from activities that is a trade or business. It's regularly carried on, and that activity is not substantially related to the organization's exempt purpose. The example that's given in the source I looked at says a charity that sells branded merchandise like mugs or T-shirts with no educational or advocacy component. Even if it's fundraising, the activity doesn't directly support the mission, so it might be considered UBI and subject to the UBIT or the UBI tax. If you and there's pretty basic stuff again, but just to compare them side by side, this slide shows the sort of, first of all, first feature, how closely is it aligned to the organization's mission. Again, if it directly furthers the exempt purpose, it's going to be related business income. If it's not substantially related to that exempt purpose, then it's going to be likely to be considered unrelated business income. As far as the tax treatment, of course, if it's related business income, it's tax exempt. And if it is unrelated business income, then it likely will be taxable, and the organization has to file subject to the UBI tax, and the organization will have to file the required Form 990T that I think Rita mentioned a little bit earlier. Examples, I've given a couple, and have those again on the chart, but that's pretty much it. So I'm going to try to stop the screen share now. All right. So I think the second part of the question was, why is this important? Why is it a trap for the unwary? And I think that for one thing, as you can tell from those examples I shared with you, what is unrelated business income and what is not, it's not always a clear line distinction between those two. So sometimes it's kind of difficult really to determine that. And the consequences can be pretty serious. as we all know, failing to file tax returns and file your taxes on time is problematic. Um, and I may be wrong about this, and Seth or Rita or somebody correct me if I'm wrong, but I think that in extreme cases it could jeopardize the tax exempt status of the organization. So that's sort of just a nutshell summary of it. Just be aware of the UBI issue. If you're serving on a board and particularly the organization starting at some kind of a new activity, some kind of an income generating activity, just be aware of the UBIT issue. Look for any kind of red flags in there, and bring it to the other board members' attention. I think that having said all that, in most cases, I don't think this is going to be a big problem for the directors, board members, depending on the sophistication of the organization. But it's likely going to have an executive director or somebody in a leadership role who's very experienced in this and know very well what's likely to be UBI and what's not, so it's probably not going to be an issue for the board, but just be aware of it anyway. Rita or Seth or Harold, you got anything to add to that? Please feel free to give an overview of it, I guess.
Thank you, Jerry. I want to highlight Brooke's comment in the chat as well that includes a link to the resources that that the panelists have mentioned today. So make sure you check those out, and they will be very helpful to provide context and in detail on some of the topics that we are addressing during the panel today. Shifting a little bit to talk about the duties and liabilities of the board of director. This is such an important component of for any nonprofit. Jerry, I know you mentioned a little bit talking about the fiduciary duties of the board members earlier. Can you kind of explain that a little bit more, what it means to have that fiduciary duty, how it relates to the board, and specifically under Tennessee law?
Sure, yeah, be glad to. Before I do that, I want to make just a couple of comments about governance of nonprofit organizations in general. And I think if I can go back to my share screen here. Okay, and I'll need to go to the next slide. Okay. Sorry, it's taking me a minute to do this. Oh, there we go. This is just a little graphic here, but if you're interested in a good, pretty good narrative summary on governance and operation of nonprofits, you might want to check out this publication. And I believe this is in the bank of documents we have available down there in the link. You can also download it for no charge from the Secretary of State's website. But it covers the duties and responsibility of board members and officers, and has some other topics of interest as well. Certainly not limited to those to the governance duties. One of the other topics that it covers is how can you as a board member make the most of your service on the board, and more importantly, how can you assure that you are delivering to the organization the most that they can get from you. And one of the best suggestions as to ways to do that or facilitate that is for you as a board member to be engaged, be involved, be an active participant in the board meetings. Sometimes that's difficult for people, especially if they're not accustomed to serving on boards that are new to it. Maybe a large board, they feel kind of intimidated. But I encourage you not to feel that way. I mean, you're there for a purpose, and you're brought on board for a reason, and and your participation and input is important. I think that the best way to enable yourself to do that is to really just be prepared. Review the meeting agenda, review any materials that have been provided by the organization in advance, and think about it. See if there's any red flags there or anything that you just don't understand or have a question about or concern about. And be ready to discuss those with the meeting. I think it'll make you better equipped to be an active participant and make the most of your contributions. So that was just some general thoughts. Let's look now at the actual fiduciary duties of a board member. And the fiduciary duties of a director are set forth by statute, TCA section 4858-301, A1 through A3. And I've just got a copy of it up there so you can read those yourselves. So first fiduciary duty that is shown in the statute is that you have a duty to act in good faith. Number two, you have obligation to use the care an ordinarily prudent person in a like position would exercise under similar circumstances. Almost sounds like sort of the standard for this negligence in a way. And three, you need to carry out your duties in a manner that the director reasonably believes to be in the best interest of the corporation. Those sound pretty easy to comply with, and maybe they are, but it's I think the statute really sort of strikes a balance between making sure that the director is always acting in the best interest of the organization, but on the other hand, not making the burdens and the responsibilities and obligations so onerous as to discourage people from serving on the board. So I think it strikes a pretty good balance there. If you go into subsection B, it sort of tells you, you have these fiduciary duties. Well, what information are you entitled to rely upon in taking actions on behalf of the organization? And there are a number of you are entitled to rely on the information of other persons associated with the organization. You can rely on officers and employees. You can rely on legal counsel, public accountants. You can rely on a committee of the board of directors, and even volunteers of the organization. But the key there is whenever whichever of those sources you're talking about, as long as the director reasonably believes that the person and the information are reliable and the person's competent in those matters, you're allowed to rely upon that information in making your decisions. If in subsection D, if you comply with those, if you act within those parameters of those standards, then the director is not going to be held liable for any action or failure to take action. Again, as long as you're acting within the parameters of those duties. The last fiduciary duty I want to mention, and it's not covered in the statute we just looked at, but it's very important, and that's the duty of loyalty. The duty of loyalty just means that the director has to act with undivided loyalty in the best interest of the corporation, and not to seek personally to benefit personally from the activities of the corporation. If there's is or could reasonably be a conflict between personal interests of the director and those of the corporation, then you have to take appropriate action to resolve that or avoid that. And if it just involves a single issue that you happen to be dealing with at the time, it may be sufficient for you to disclose the conflict or potential conflict and recuse yourself from any action on that matter. But sometimes it may be such that it really is going to involve almost anything the organization does, and it may require resignation from the board. But again, just be very aware of that. We as attorneys are, of course, always keenly aware of potential conflicts. And in this case, it's just between your own interests and those of the organization. And so be aware for that. Be aware of that. I'm going to go off the screen share now. So anyway, sorry for the long answer. I hope that was somewhat helpful. And Claudia, turn it back over to you.
Thank you so much, Jerry. And it absolutely speaks to the next topic we want to talk about. In order for your board members to be clear about these responsibilities and duties, it is very important to have board training. So Harold, can you talk about, in your experience, how nonprofits can better train their boards to understand these duties that we just discussed?
Absolutely. And this is a topic that is quite timely for me because two of the boards that I serve on have recently recruited individuals who are ready and willing to serve, but have no prior nonprofit board experience. So they've, been voted onto the board and are like, well, now what? And so in working with the executive directors and leadership of those organizations, I have made recommendations of some ways, and we've implemented some mechanisms to really get that training to the board members. And so I have just 5 tips that I want to share. First, I would say that new member orientation is a good time to really introduce those fiduciary duties to board members. Because again, when you're recruiting people, they will likely have a broad range of experience. Some will come in with nonprofit board experience. Others will be completely new to it. And so I found that whatever onboarding mechanism you have, that you incorporate at least sharing and providing some written materials and resources that lay out those fiduciary duties to introduce them to that, so that all board members will understand their responsibility. And then I would say after that, an annual group training for the board is a good idea. That can be done at the beginning of the board's or the organization's fiscal year. You might want to carve out some time in that first meeting, or maybe even done at a board retreat. Oftentimes when you hear the word retreat, you think of something fun and enjoyable, and that is a lot of it because it helps build morale among the board, but that also gives the board time, focus time outside of their regular business meetings, to not only focus on things like reviewing the strategic plan of the organization and looking at development and fundraising strategies, but also to have a refresher on what those board responsibility and fiduciary duties are. Now, in terms of providing that annual training, the organization could hire a nonprofit consultant. I know that there are several here in Chattanooga that are very good. They are all experienced, either former directors, executive directors of nonprofit organizations, and or have served on boards themselves. But as we all know, consultants do charge, they do cost money. So if that's not feasible, then just again, redistributing those written materials that are professionally published articles and flow charts and guidelines on what the fiduciary duties are. It also can be helpful to seek out other nonprofit organizations within your community that provide support to nonprofit organizations, including board member training. I know there's a great organization here in Chattanooga, the Nonprofit Resource Center. They actually offer a board governance training series. I have attended it myself. I found it to be very helpful, and they offer it at no charge for like up to 2 or 3 members of the board. And also UT Chattanooga, University of Tennessee at Chattanooga often works with the Nonprofit Resource Center through their Department of Political Science and Public Service. So they also provide that training. So I would just encourage you to seek out what are the resources in your community that professionals offer to give that training to folks. And then I want to echo something that Seth mentioned earlier, and that is your board bylaws. The bylaws will oftentimes have a responsibility section, and it's important to have, a statement about those fiduciary duties, because that provides the board members with a written document that's specific to that board for that organization that they can refer to if they have questions. I know that I have very recently, well, actually, I'm in the process of leading 2 of the organizations with reviewing and revising the bylaws. And so, as Seth mentioned, it's not a document that just stays dormant. And that's been a good exercise and opportunity to get the board together and to look at those fiduciary duties as well as other things and keep it on their radar of what they should be doing in their role. And last but not least, I found that starting at the top of the organization, make sure that your executive director and other organization leadership know those fiduciary duties and understand the responsibility of a board. 2 of the organizations that I currently serve on, the executive directors themselves are relatively new to the nonprofit space. And just through experience, they realized that they did not fully understand initially what the responsibility of that board of the board is. And so when they came to me, because I'm the chair actually of the board of both organizations, they came to me with some concerns. And again, once we talked about it, we got to the root of that. They themselves needed some training. And so I encouraged them to not only speak with their peers within the community, other nonprofit leaders, but to also seek out formal training. I know here, United Way of Greater Chattanooga has the CEO Circle, and that's where executive directors of local nonprofits, I think, get together once a month, and they share experiences, bounce ideas off of each other, and seek guidance. And one of the executive directors or the executive director of one of the organizations has been attending that, and she found it to be immensely helpful as she's going through those learning curves of how to lead a nonprofit. So that would be my guidance for really how to keep your board, as Jerry said, engaged and aware of their responsibilities.
Thanks so much, Harolda, and completely agree. Those bylaws need to be a living document, especially since we're talking really about the formation of the nonprofit. You want to make sure that as you're growing and you're getting into the work of the nonprofit, that you're updating and making sure that that work is reflected for what best serves your organization. Rita, I know you mentioned earlier, you talked a little bit about D&O insurance. I do want us to talk a little bit about the potential for personal liability here. How can nonprofit organizations protect their board members, and what kind of policies or insurance do you recommend?
That's incredibly important. Directors and officers insurance is usually the standard. So basically, that's the policy that the nonprofit has that's going to protect the board of directors from liability for decisions that they make in the scope of their duties. It's important to understand, just like when we practice law, that we're staying within the scope of our responsibilities. So as long as you're operating within the scope of your responsibilities as a board member, and you're also adhering to those standards that Jerry talked about, good faith, care, loyalty. In some jurisdictions, they replace the the duty of loyalty with not loyalty, but with good faith with obedience. So it's loyalty, obedience, and care. So making sure that you understand your role as a board member and that you're acting within the guidelines of that standard of care, of loyalty, of good faith or obedience. A lot of board members, um, they kind of abdicate, and this has just been, I've served on boards, I've worked for nonprofits. A lot of board members somewhat abdicate their responsibilities to paid staff. And so you'll have a chief executive, and a lot of nonprofits, you'll have that chief executive that is supported by an executive team, and they rely heavily on that executive team and that chief executive to not only run the organization, which is within their scope, supposed to be concerned with operational responsibilities, but they not only do that, but a lot of board members basically abdicate their roles for stewardship, oversight, and guidance. The board of directors, that entity serves as the fiduciary. So you have those fiduciary responsibilities, and they also are legally liable for the organization. So, in the case of a 501c3 nonprofit organization organized in the state of Tennessee, the chief executive and the executive team don't own that nonprofit organization. The board doesn't own it, but they have the legal responsibility for ensuring that that nonprofit organization is working within the scope that it's supposed to work within, adhering to regulations, all compliance, things like that. And so I often say, when you serve on a board, you might be serving on a board just because you were asked. You might, have an affinity for that nonprofit organization because they're doing something that you really believe in. But I also tell people that that's a job. You should not be showing up to, a board and you haven't read the materials, nor should you be receiving your materials a day of your board meeting. Those should come well in advance. I know some boards, they'll be given a packet of information, whether that's given to them electronically or hard copy, however they prefer, and those materials are thick. You may not have the time to look through everything, but you need to be competent enough to know what you need to look through and be given the opportunity to have enough time to really focus on that. I think every board member needs to have just a rudimentary understanding of finance. So can you read the balance sheet? Can you, look at these financial documents that are being prepared by the finance staff and understand whether or not things, are operating, properly? Do you see some issues with cash flow? Are there too many accounts receivable? Has projected grant funding not come in? Things that you really need to understand and be cognizant of. And so the board should not overstep its parameters and get into the weeds of operations and daily operations. That should be the executive team that's focusing on that. But the board needs to be really cognizant and really understand what they should be doing. And that stewardship or guidance and oversight is definitely a role that they need to play. So, if you abdicate that responsibility, if you're not adhering to your standards of care and loyalty, good faith, obedience, then that opens you up for liability. You can rely on the executive staff. You can, have confidence in your leadership if you've got the right people in place. But that does not absolve the board from basically knowing what is supposed to be done for that nonprofit organization and keeping their fiduciary and their legal responsibilities at top of mind. Because then when you don't, that's when you open yourself up for liability, whether that liability is going to be covered by D&O insurance or not. I mean, that's up for the lawyers to decide. And if it goes to litigation, for a judge or a jury to decide. But you can mitigate the risk of liability by basically adhering, to your duties and your responsibilities. And I think a lot of board members don't understand that. And so, as Harold has said, board training is essential. And it's not something that should just happen one time and you're done during orientation. It should be ongoing. And I always advocate for it to be done by an external party that is skilled in that area, because a lot of times nonprofits will rely on homegrown staff or, a board member to carry it out. And you need an objective eye, an expert, an objective eye to come in to analyze how that nonprofit organization is operating and really be a truth teller to say there are some real deficits going on, or there are some real opportunities for change, and that person on the outside is better, equipped and situated to deliver that message and guide the board through the steps that the board needs to go through in order to optimize, their governance structure and the operations of the nonprofit.
Thanks so much, Rita. I see we have a couple more questions, and I really want to make sure we have an opportunity with taking a peek at the time to talk about branding, which I think is a really important issue here. So I want to make sure we have time to address that. So please, we can absolutely come back to these questions that we have in the chat. But in the interest of time, I want us to sort of dive in a little bit about branding, especially in the age of social media. It's so important for nonprofits who are trying to share about their mission and stand out and fundraise. Seth, I know this area is very much in your wheelhouse. Can you talk to us about branding and name protection and IP concerns that nonprofits have?
Sure. And we got to be respectful of time. So I'm going to go kind of quick and let everyone know, like, it's free always in my realm to talk, call and ask me questions. I can explain the different types of IP to you and those things. And even if your nonprofit may not be interested in hiring someone, I can give you advice on which things are doable on your own versus things that you may need to be, what would I tell my mom if she came to me and said, I want a trademark and I'm going to do it myself? I can kind of tell you what I would tell her. But the main thing is you're going to build brand equity, right? Like, you may be a nonprofit, but you're not like, you're the same as any other business when it comes to advertising. So the first thing is you better choose a name that someone else is not using, because the worst thing to see is 5 years down the road when it gets around and you're becoming, you've got people donating money, you're getting larger, to get a cease and desist letter that says, hey, you can't call yourself that. And this is not an uncommon occurrence. The best example out of the business world has to do, I think, with craft breweries and beer. There have been wars fought across the country because two people named a beer the same thing, one on the East Coast and one on the West Coast. And it didn't come to a head until they were big enough that they're selling large volumes of these beers. And names have been changed. And they had to change a complete name of something that they had brand equity in. It's less common in nonprofits, but what you'll see is a nonprofit may get too close to an actual business that has a registration. Then that business is going to reach out. And is it a good look for them to sue a nonprofit? Probably not, but it doesn't mean it won't happen. And I've seen this before. So you need to figure out a methodology to search. There are free search tools on the USPTO website for searching federal trademark registrations, but try to clear that name first. There may be organizations, there may be law firms willing to do a trademark search for you pro bono, because there are more places than just federal trademark registrations. But you need to look and you need to understand. And the thing is, the question is not, are you using an exact word? It's, is there a likelihood of confusion? Would someone think your nonprofit is associated with another nonprofit? What is the source and origin of your services? So that's what you need to think about. And that has not only to do with the name of your organization, but slogans you may come up with. So it's not an issue, but for example, Operation Stand Down, their name is Operation Stand Down Tennessee, but their slogan is engage, equip, and empower. And so you want to make sure that that is also not a problem, because you don't want a letter from somebody like me. So that is the first thing. The other thing I'll talk about, so there's that, then there's protecting your own brand, because what you don't want is for someone else out there to be coming, and maybe doing something with your brand name that you don't like. There are different types of registrations. They cost different amounts of money. You can get a state trademark if you don't think you're going to expand or that plan is way down the road. That's an easier way to go. You can get a federal trademark registration. And again, this is for branding. There's copyrights as well. That's a different thing. What I'll note on copyrights, it goes more with social media, which is kind of the next topic. But I may just jump right into that in a second. But with copyrights, that's the idea of if you're going to be posting things, you probably don't need to register your own copyrights. That's probably a little beyond what you need to do unless you start publishing. And at that point, you may need to think about that. But you need to be sure you don't infringe others' copyrights. So, one of those, like a weird example of this, and typically they won't come after you unless it's a commercial use, but the murals. If you take a picture in front of that Wings mural in the Gulch and you use it in a magazine and you don't pay for it, you are going to get a cease and desist letter from that trademark owner. So you need to think about the things that you're putting up on the web and make sure that those are your original creations or you've cleared the copyright. So there's a couple ways to do this. One way is to, and you still have to be careful here, but to go to websites that have licensed images and pay for the licensed images, and make sure you use those. The greatest tool is if you have a subscription to an AI that will generate images, you don't really have a lot to worry about. Tell it what to make and let it make it for you. Now, you need to not like go and take someone else's image and say, use this image and make this, but that's really, honestly, that's what I do in presentations now because it's the easiest way for me to know that I'm pretty clear is to create from scratch through AI an image. So those are the two biggest things because they can just result in unneeded costs because there are trademark bullies and copyright trolls that exist and they're only out there to get money. The other thing is if you get one of these letters ever that is a problem for you, talk to an attorney about it because some of these are not legitimate. These copyright trolls, there are many from foreign countries, they don't actually own the copyrights. And if you send them a letter back asking for the registration and the proof of ownership, you never hear from them again. So those are kind of the biggest things on, your branding that I'll talk about right now. Again, you can ask me questions. Social media becomes a little more risky. And, I mentioned the copyright aspects of that. Be very careful about posting and even reposting. If you're reposting, make sure that it's something that you feel like doesn't have a copyrighted image in it. And then one other thing I'll talk about on the social media risks there is you do need to kind of distinguish within, and this goes back to roles and responsibilities. Who is authorized to speak on behalf of the organization? Who's going to have the credentials to post on social media for the organization? And do you want to have a policy that for board members and or staff that they need to clarify in their own personal posts, whether they're posting in a personal capacity or on behalf of the organization? And you need to be clear with people that, and this would need to be in some sort, and you talk to an employment lawyer about this, but you need to be able to have issue. If someone says something on social media that's generally, abhorred by a lot of people, and they say it in their personal account, but everyone knows they're associated with your organization, you need to have things to bring them to account for that. Whether it be discipline or maybe they have to be terminated because that can be a huge damage to your organization if they're not being careful on social media with that. Then you have confidentiality issues on social media. So you may have confidential donor or client information. You got to be really careful about posting that. I'm aware of donors to different organizations that are completely confidential. Only like two people at the organization even know who they are. They don't share that information with the board. And so you have to be very careful with that because many donors are very intentional about where and when they want their name disclosed. And then the final thing is content ownership and usage. So again, this goes to like if you have a photographer take photos for you, you better be sure that they're transferring the ownership rights to you before you start posting them everywhere. it's kind of like even when you get wedding photos, right? The license doesn't transfer until the payment and everything is complete. So you have to be sure that you're careful about that. And then the other big thing is thinking about if you're going to place people, if you're going to take pictures and videos at an event. Now, generally, and you'll need to look into this for yourself. I'm not going to give legal advice here, but generally, if it's in a public space, then it's probably okay. But are you going to have pictures of children there? I'd be extra careful. You never know if a parent is upset if that goes up. And so more of it is just about you don't even want to deal with it. Even if you were in the right, you don't want to have to deal with it legally. And so, for example, there are easy contracts. If you know specifically you're going to video record something, then you probably need a name, image, and likeness release from that person. I've worked with a nonprofit that specifically that's what they were doing. They were telling stories about Gold Star families. So, and they came to me and said, I want a release that they sign before I put the video out that has them. And you need that says that you have rights in perpetuity forever. And it's crazy when you read the language. It's like for all time and ever, I can use any version of this in anywhere in the universe. I think they are using that word now because we know space travel is about to happen. So you want to have this sort of thing in place. I know it's a lot to think about, but the best practice is look at it, say, is there anything that is somebody else's in there that we might need to clear? And then also, do we have pictures of people that may not want their pictures there? But, look, if you take a picture with somebody standing there with a check that they've just donated to the organization, you can be pretty sure they're probably going to be okay with you posting it. But even better if their organization posts it first and then you repost it, then you're totally in the clear. So you just kind of want to be logical about this, but, give me a call if you're worried about it and we can talk about it. So I think I covered two topics and we only have 6 minutes left. So I think hopefully that's perfect timing.
Thanks so much, Seth. And I'm really glad you touched on social media as well. We do have a story from one of our board members from Harold that I think would be great to share here. I'm mindful of time, but Harold, take it away.
Okay, I'm just going to give you all the condensed version because the situation that I'm currently dealing with is I think pretty unique. I serve on the board for a dance company. It's a nonprofit dance company that focuses on youth outreach and education. But prior to that, it originally started as a nonprofit dance company that engaged with the Chattanooga community through immersive dance performances. And while it was in that life of the organization, the organization created a film. It was a film that featured about 7 of the dancers in the company, and it focused on themes of like empathy and human nature. It was a very powerful film. But the problem is that when after the focus of the organization pivoted, that film really no longer aligned with the youth outreach component of the organization. Nevertheless, the organization, we still own it, but we're in the process of actually assigning the rights to that film. And that discussion came about when the former executive director and one of the co-founders of the organization actually approached the current executive director and myself as the board chair a couple of months ago and basically said, I, along with the other co-founder, we essentially, they didn't know how to legally approach it. They just basically said that they wanted to be the stewards or spokespersons for this film. And I wasn't sure about that. And so I encouraged the board to slow down and kind of assess what our options were. And ultimately, this goes to a point that has been mentioned here several times today. I said, I'm not an IP attorney. I wanted to be when I was in law school, but I'm not. So we need to find someone with the expertise we can consult with and give us our options. we ultimately reached out to the Nashville and Business Council, their volunteer lawyers and professionals for the arts, and was connected with a great IP attorney who is in the process of advising us. The organization is probably leaning towards assigning the rights to that film completely because of a number of reasons. But my takeaway is, and again, we've touched on this, and as Seth pointed out, there are a lot of considerations when it comes to IP. And sometimes the best thing to do is just to get with someone who knows that area of law. And that was really, I think, what I'm most proud of as the attorney for the board was making that recommendation and connecting them to someone who can help. So I would just encourage you all to keep that in mind when you're approached with things that are outside of your wheelhouse.
And I'll mention, I know at least two or three other IP attorneys in addition to myself that would certainly be willing to do pro bono advice for things. If you're in the arts, there's another attorney in town that I'm pretty sure would be willing to help you out, like with some initial advice. Typically being that like, unless we have to pay for some sort of IP, application, like pay the fee. And they might cover that pro bono as well, that they'd be willing to just talk to you for free. So really, you should reach out because we all have so many connections within the local legal community that I think we can find somebody to help you if you really need it.
Thank you so much. I see we are right at the end. It's almost 12:30. I want you all to know that we are copying and tracking the questions that have come in. Today will not be the last session, so I invite you all to join us for the next CLE session. Before we wrap today, I want to thank you all for joining us. I want to send a special thanks to Rita, Seth, Harolda, and Jerry for your insights and generosity and sharing your wisdom and experience here. Also, thank you so much to Brooke and the Tennessee Bar Association for their support for this event. We hope this has been helpful for you. Please, again, be on the lookout for our next CLE session, and we hope you all have a great day. One other thing I'll add is if you have any additional questions, feel free to reach out after the program, and please make sure you get the link that Brooke added to the chat that connects you with the resources that we've mentioned today, which will also continue to add resources as we move through the different sessions. So thank you all so much for joining us, and I hope you enjoy the rest of your day.